to you, Vladyslava.
Thank you very much. And thank you to everyone for being patient with us and with the technology today. It's been a long way, but we are really glad to welcome you to our partners event organized by VIAC, the Vienna International Arbitral Center. And the first thing I would like to thank the organizers of the forum, especially Luisa and Svetlana, not just for the invitation, for the possibility to be here, but also for reacting so quickly and for fixing the tech issues so that we can start with the panel. Насправді чудово, що в такий важкий час.
Actually, this is so great that in this difficult time, we have such large-scale initiatives, and I'm so glad to see so many my fellow Ukrainians here in our audience. This is really inspiring.
The title of the event sounds Expanding Opportunities for the Resolution of Disputes, Mediation as Part of the Arbitration Ecosystem. Today, our sort of main goal was to bring together in one audience mediation and arbitration enthusiasts and talk a little bit about the efficient ways of how to combine these two approaches. We will focus on advantages and risks, the when and how of twinning, as well as ethical and enforcement issues. We will have the Q&A session in the end. But yeah, please, whenever you have a question, you want to ask something, please put it in the chat and then we will get back to it in the end of the discussion. It's my honor to introduce to you our esteemed panelists. All of them are highly experienced mediators and arbitration professionals. But first, please meet my amazing co-moderator, Natascha Tunkel. She's already joined us. Natascha is partner at KNOETZL and has over 15 years of experience in the field of complex dispute resolution. Commercial arbitration and mediation are at the core of her practice, and her experience covers a wide area of disputes and industries. With a keen interest in and understanding of new technologies, she has a particular specialization in the fields of life science, energy, engineering, and intellectual property. Natascha currently serves as a member of the VIAC Mediation Advisory Board and as vice chair of the IBA Mediation Committee. Her expertise in the field is internationally recognized. She is listed as Next Generation Partner of Note in Legal 500, Rising Star in Juve, Next Generation Global Elite Thought Leader in Who is Who Legal. So as for the panel, everyone certainly knows Thomas John, wearing the hat of the CDRC Mediation and Negotiation Competition Director. Thomas practices globally as an international mediator, arbitrator, negotiator, and legal consultant. Based in the Netherlands, he is common and civil law trained and fully bilingual. He speaks English and German. Accredited by the Chartered Institute of Arbitrators, Thomas has a keen interest in resolving commercial, corporate, and investor-state disputes, but also disputes relating to MSMEs, travel and tourism, business and human rights, startups, as well as to international organizations, their staff, contractors, and consultants. Thomas also specializes in disputes relating to art and cultural objects and is a panel arbitrator of the Court of Arbitration of Art in The Hague, Netherlands. A particular area of his interest is the twinning of mediation and arbitration, which has brought him here today. He teaches mediation at universities and trains lawyers giving mediation courses. Amelie Huber-Starlinger is well known both in arbitration and mediation circles. Amelie is an independent mediator focusing on national and international commercial mediation and negotiation consultant. She is accredited as a mediator in several jurisdictions, including Austria, England, and Singapore, serves on the VIAC Mediation Advisory Board as well, and regularly judges international mediation and negotiation competitions. She is a frequent speaker and author on mediation and conflict management. She is recognized by the Lexology Index as a global elite thought leader and received the 2025 Client Choice Award in Mediation in Austria. Last, but certainly not least, is Mary Walker, who probably doesn't need an introduction as everyone is familiar with her many achievements. And with Mary's permission, I will only highlight a few. Mary has been at the forefront of ADR in Australia for the last 35 years, during which, as a member of the independent bar, she has arbitrated, acted as expert determiner, an expert appraiser, provided ombudsman services, mediated, facilitated, and negotiated across jurisdictions and substantive legal areas. Mary was induced into the Austrian ADR Awards Hall of Fame as its inaugural member in 2019. She was originally a member of the IMI Independent Standards Commission and is currently a member of the IMI Ethics Committee and IMI Quality Assurance Committee. In 2017, she was appointed a Fellow of the Austrian Dispute Resolution Association for outstanding contribution to Australian dispute resolution, and was later awarded the Medal of the Order of Australia for service to the law by the Australian Governor-General. So this is our amazing panel who will be presenting their topics today. And on this, we could perhaps turn into the first one, and I'll be happy to pass the floor to Thomas, who will kick off the discussion today. Tom promised to play sort of the devil's advocate today and will tell us why the title of the event is a bit controversial. Is mediation really part of the arbitration ecosystem? Thomas, in his presentation, will further focus on advantages and risks of twinning mediation and arbitration. The floor is yours.
Yes, thank you very, very much, Vlada, and hello, good afternoon, good evening, good morning, good night, wherever you are at the moment in the world and tuning into this broadcast. Can I start by thanking the organizers, in particular Luisa, Svetlana. Again, wonderful event that you pulled off here. Thank you so much for having me. It's absolutely a great privilege and honor to join you. And I can't wait to see you in about 2 weeks' time for the CDRC here in Vienna. Thank you also to Natascha and Vlada for sharing us today. It's really a great pleasure to working with you again once more. And can I also say, and this is maybe a little bit unusual, but thanks to the interpreters that we have today. I know this is a big job, a massive job. It's a difficult job because you hear loads of different accents and dialects, and the English is sometimes sort of getting a little bit lost as well. So thank you so much in advance for all the translations, or the interpretation you actually provide. Now, devil's advocate, I don't want to be too much of a devil's advocate or give away my game straight away, Vlada. It's not a problem at all. Yes, it is part of the arbitration ecosystem, but I would very much pose the proposition not only. It is so much more, but that's certainly a very important element. But let's start at a slightly different point. Earlier this year, and many of you may know this competition, was the Wismut 2025. It was the 32nd edition of this competition. And one of the key issues, or one of the key problems that arose in this moot competition and needed to be tackled by the students was a tiered dispute resolution clause. Now, we don't have to disentangle the whole legal problem here, but the dispute resolution clause essentially contemplated in the first place mediation, and then said final settlement would be by arbitration. So we have a tiered system which contemplated both mediation and arbitration in succession. Now, both of those are, of course, part of the dispute resolution ecosystem. And this is why I say, yes, mediation is part of arbitration ecosystem, but it is so much more, it's so much broader, because we definitely can say it is, together with arbitration and with litigation, part of the broader dispute resolution system, if I may call it that way. And it is a fundamental tool of every dispute resolution practitioner, as is arbitration, as is litigation, and each of those processes at their appropriate time. Now, they're also referred to, arbitration and mediation, that is, often as alternative dispute resolution processes, to mark that they're an alternative to litigation. Yeah? And that is something that we need to keep in mind when we discuss this today. Now, the dispute resolution clause in this case created actually something that we call a sequential use of arbitration and mediation, or mediation arbitration in this instance. First mediation, and if it fails or is it unsuccessful or only partially successful, the remainder will be resolved through arbitration. One of the key issues that arose in this case was that one side was arguing because mediation didn't take place, we couldn't go back to mediation anymore. And the parties had to argue one way or another whether it was possible or not. Again, we don't have to go into this, but that's one of the problems that can arise when we actually start creating a combination or twinning, as we call it at the CDRC, of mediation and arbitration processes. Again, we're talking about the combination of the two, the twinning of the two. It could be topics that you or phrases that you heard before: med-arb, arb-med-arb, med-arb-med. There's a variety of those. We group them together into what we call twinning. The only reason why we do that is because there's so many permutations, there's so many options to use mediation within arbitration, or arbitration propagated onto mediation, combining all these processes with each other, with the focus on providing the best possible solution for the client in the shortest possible and most economical time. Now, why do we even consider the combination of the two? What are some of the reasons why we would actually do that? Now, the power in the combination is that essentially we can use what we call what I would refer to as the most appropriate process at any given time in the life cycle of the dispute. It doesn't matter whether we go in with arbitration or litigation, even for that matter. It doesn't matter whether we have mediation first and then arbitration. It is really more the focus of our endeavor to resolve the dispute by whatever means necessary that results in a good outcome for the parties, and that is quick and that is fast. Now, we combine the processes, in other words, in order to unlock certain synergies between these processes. We look at increased flexibility of the process. We look at increased efficiency of the processes by combining them at appropriate points in time. And that then results in increased speed of resolution. And we all know that the most expensive thing in resolving a dispute is the time it takes to actually resolve it. And so if we can speed up the process, then it is actually something that really benefits the client, because they get a quicker resolution, they spend less resources on it, and they need to pay less money essentially for it. It is less costly to resolve. But it also allows us, and when we look at, in particular, at mediation as a process, it allows us to incorporate through the process of mediation more creativity, not only flexibility, but creativity in actually finding solutions that are based on the interests of the parties, as opposed to just being a plain application of the law. We also tend to achieve with that a better integration of the parties. Now, when I say that, one of the key issues, or one of the key benefits of mediation is, of course, that the parties remain in control from the beginning to the very end of both the process, but also the result of the mediation process. Now, when we combine the determinative processes like litigation and arbitration, but in particular arbitration, with mediation, we can actually import into the mediation process this very notion of involving the parties, bringing back the control of the parties into the process, into the dispute resolution process that we are currently designing. It's also opening opportunities to find solutions that may not necessarily be capable of being ordered or granted by a court or by an arbitral panel. The classic example, as far as I'm concerned, is the apology. Very often, or the expression of regret, as we often refer to avoid the connotations that are associated with apology. But very often, I find in my practice that at least one of the parties, regardless of all the other issues, one of the things that they really want is to have the other side saying that they made a mistake. And so you can actually get, as one of the elements of the solution ultimately for the dispute, an agreement that one of the parties actually issues a statement of sorts. And that's not sort of something that a court could order. That's also difficult for an arbitral tribunal to actually order, because it's not part of the legal repertoire, or not the portfolio of remedies, if I may call it that way. And finally, the combination of the processes can actually induce a quicker settlement. Now, that has to do with the fact that on the one hand, when we go into mediation, as I just said before, we can bring back the control of the parties, and the parties start owning the dispute again and start resolving their dispute with their solutions. So that's one effect that we can achieve. At the other side, on the other side, we can also, when we propagate arbitration or backend with arbitration, there's a point in time where they lose this control and arbitration takes over. And these are often junctures at which parties are more willing to resolve because they have come a long way already towards each other. And rather than losing what they have already negotiated, they're then more willing to actually and more ready to jump over the line. So what all of that shows is there's a lot of benefits, potential benefits, in twinning mediation and arbitration. And often it comes down to a strategic choice how to set this up already in a contractual environment, and we will talk about that a little bit today as well. In the actual dispute resolution process as well, if we started off with arbitration, how do we put in mediation, inject mediation into the process, or the other way around? These are often more strategic decisions. They also require certain windows of opportunity, and we will talk about that too today. There are windows in which mediation and arbitration can be combined very well with each other, and these windows we just need to know and find, and we need to know how to react to them. There are risks involved, and we will hear quite a bit about those risks today. And much comes down to, and Mary, I love this terminology, you coined that for me at some stage, and it's the process design. It's a almost standing topic nowadays. This process design really has to be spot on in order to make this work. And it not only work in the sense that we actually get good outcomes, but also work in the sense that we do not open ourselves up for risks or open the parties up to risks that they have not anticipated. And I'm just saying here, there's some enforcement risks later on if we get it wrong. There are essentially risks that the entire dispute resolution process fails because we have done somewhere along the line in the dispute resolution process design a mistake.
Tom?
I think I have 7 minutes, and I think that was.
I think I was about to say, Tom, I think we've just reached, that first.
Yes, and I was about to wrap up because that was essentially my 7 minutes, and I just saw it, and I leave it there. Yes, thanks, Natascha, for reminding me.
Thank you, Tom. That was a perfect introduction. So thank you for setting us off on this note. I do have 2 follow-up questions in that context right now. I'd like to put to you, as you've noted, some of the points we'll address later on as well. But up front, I think I might be the devil's advocate right now. I'm going to ask the terrible question. What precisely are those synergies, especially in light of the fact that many lawyers or clients may come and ask the question, you're asking us to do 2 processes instead of 1. Like, that's double the effort. Am I going to be doubling the effort? Why should I double the effort? If you could pinpoint that would be helpful. And I'll leave it there for the time being. I have another follow-up question after that.
Yeah, indeed, you hear this quite regularly. I usually try to explain it to the parties. The preparation for an arbitration or preparation for mediation are not dissimilar. I still have to go through the motions. I still have to understand the case. I need the facts. I need to understand the facts. So by the end of the day, the preparation is the same. I need to do the risk analysis properly. I need to understand where the weaknesses of my client's cases, etc. So from a lawyer's point of view, from a client's point of view, the preparation is actually very similar, and from my point of view would also actually entail the same costs. Now, where the synergies come from is that if I get the process design right, if I advise my client appropriately on the use of the combined use, if I may call it that way, the twinned use of those processes and apply in a strategic sense at the right points in time, the right processes, then I can shorten the time it will take to actually ventilate all the issues through one process as opposed to the other process. It doesn't double up on time. It doesn't double up on, if it's done properly, it doesn't double up on costs. In fact, actually, it can shorten the process, and with that, it actually can shorten also or limit the amount of money that I have spent. So there is actually a synergy effect in the sense that we have more efficient, more effective process, shorter process, and with that, I have to pay less because it is actually quicker resolved the issue. Now, there's also maybe a further issue that one could add on to that. And we know that the compliance rate with mediated settlement agreements is very high. And so, because the parties own the outcome. So if we actually find a way through the dispute and end with a mediated settlement agreement, the risk that I have to spend additional money in order to actually get like an arbitral award enforced in a foreign country, or even worse, probably a court judgment enforced in a foreign country, is far less lower because of the high compliance rate with it. So they're the two elements that I would normally explain to a client. And that answers your question.
It does. It does. It does. I mean, I'm just checking whether we have any questions right now in the chat, but it seems as if at the moment there are no questions. And what I'd like to do at this point is, because you've mentioned process design and windows of opportunity a few times, and we sort of time is moving forward. I'd like to pass back to Vlada to introduce the next topic we'll be addressing together with Amelie. And Tom, I think we'll be circling back to you a bit later to discuss, the international private law aspects that we might want to consider as a risk factor. So Vlada, back to you now.
Yes, we will be building up sort of further on what Tom was introducing. Also, the first thing that people imagine when they hear about the combination of mediation and arbitration, it's exactly this ARB-MED combinations, the standard ones. However, as we've been talking, there are so many other windows of opportunities that open along the way. So it's interesting to see how these time factors plays a role and which aspects influence the time when mediation is actually introduced into the proceedings. So I will hand over to Amelie, who will tell us more about these factors and how and when mediation can be most efficiently be integrated.
Thank you. And I agree with everything Tom said, in particular thanking Vladyslava and Natascha for the fantastic moderation, and of course the Ukrainian Academy of Mediation for organizing this event. This being said, let me just jump right into the topic, timing. The question of timing is not easy to answer because it all depends on the case. There is no clear-cut timing where you can say that's the right time to do it. It all depends on all the things also Tom said and reiterated about what is the beauty of mediation. Like, do the parties wish to have control of the outcome? Then mediation might be very much suitable in the beginning. If they don't want it to be responsible for the outcome in the beginning, you might have a mediation window in the end. So it very much depends on the parties involved, the dispute involved. If you have a very complex technical issue where the parties just cannot agree on, you might want to wish to have that decided by an expert first, and then you can move on to quantum or liability issues within a mediation procedure. But what I would say, what it all comes down to first is, and what is of utmost importance, is that you have a contract clause or a clause in your contract providing for a mediation window. It doesn't need to be obligatory, so it does not need to say for a starter that mediation needs to be the first procedure to go to. But it has to emphasize that at one point in time, you and the other party will think about mediation and the appropriate timing of mediation. Because then you're already at the beginning of whatever other process you chose, either court proceeding or arbitration, you would still have, like at the very beginning, a thought of the parties and their counsel of, oh, mediation exists too. What is mediation and how can I use it appropriately? So I think the first starting point is you have it as a contract clause in your contract. When it comes to the different possibilities of Med-Arb, Arb-Med, Arb-Med-Arb, I think one of the major issues deciding when to enter into mediation is the question of enforceability. Coming from an European country, Austria, as long as you are acting within the European territory, where the directive of the European directive on mediation and cross-border mediation applies, and the member states actually inserted legal provisions to convert a mediated settlement into a judgment or any other enforceable document, you are well prepared to actually have an obligatory mediation first to see if that actually works, and then move on to court proceedings. Because then you could, at least in Austria, you can go with a mediated settlement to the Austrian court and they would transfer it into a court judgment, and you can actually enforce it wherever you want within the European Union. So, but as we are here on an international audience and panel, that will not help you if you have, for example, a dispute between Austrians, and let's assume I am in dispute with Mary, which I'm not, but if we have a dispute and I would like to enforce a judgment, an Austrian judgment in Australia, I would actually be it would be burdensome, if not impossible. So as soon as you enter an international sphere and think about how you might actually enforce a mediated settlement, you have no other way than to apply Arb-Med-Arb procedure. Because of the New York Convention, and I'm pretty sure you're all very well aware of that, but the New York Convention requires, or it is argued that it requires you to commence arbitration first, then to move to mediation, and then to get an award on agreed terms or a consented award. And only in that case, it would be an award that you could enforce almost everywhere in the world. Unfortunately, we, as again, coming from a European country, the European Union did not sign the Singapore Convention yet, and we hope that it will do in not tomorrow, but very, very soon, because as soon as the Singapore Convention applies, we don't need the work around with arbitral proceedings anymore. We will just have a possibility, a legal instrument to enforce mediated settlements. That's what we all Europeans hope and dream of. But so far, we need the workaround with Arb-Med-Arb. When it comes to Arb-Med-Arb proceedings, so first initiating arbitration, then go into mediation, then again to arbitration, I think there are 3 possible time slots for you to enter into mediation. So the first is right at the beginning. it's when parties actually would like to mediate, but because of the enforcement issues, they have to enter into arbitration first. So everything until the case management conference or within the or at the case management conference is like the pre-arbitration stage, where parties would wish to mediate but have to use arbitration to get it enforceable in the end. And then we have like a mid-arbitration stage from, let's say, the first submissions. So when you get a first initial idea of what the case is about, until at that stage lasts until the final hearing. So before the arbitral tribunal actually goes back and sits together and thinks about how to decide that case, that is the middle stage. You get the more you progress in the arbitration, the more written submissions you exchange, the more witnesses you've heard, expert witness, factual witnesses, the clearer you will be on what the risks are associated with your case. So the easier it will be for you to do the risk assessment in the mediation, actually. And then we have a last stage, which is after the final hearing and the arbitral tribunal moves to clear their thoughts, write an award. And it actually, at that point, when they wrote their award, they signed it and they sealed it. And it's on the, like, either on at the institution already to be delivered to the parties, but not yet delivered, that you have like the last window of opportunity to settle. Why would a party settle at that time? It's, I have to admit, the more you progress in an arbitration, the less likely it is that the parties are still hungry to settle their case. Or yes, they're just less likely because then they are too positional, and the mediator will have to do a lot of effort to actually get them back from where they are now and go to the interests. But it happens indeed, that at that very late stage, parties still, and now knowing everything about the case, and possibly thinking, oh, that arbitrator asked this and that question, that might mean, and so having concrete speculation about the possible outcome, that they are still likely to enter into a mediation and still regain the power to settle their case by mediation. This
Amelie.
being said, I think I'm done. That's all I want to say.
So that was perfect, and I'm going to apologize to all of you for, stepping in. I know that you are very conscious of your own timing, but I thought it might be helpful just to flag it a little bit.
I'm very glad to do that.
Perfect timing, both to Tom and to Amelie, and thank you for building up on what we heard from Tom. I'm again perhaps going to ask one of the most difficult questions, I think, because it's the question I keep getting from clients as well. Namely, what if it's not in the contract? That's what you started out with. What if there's no mediation clause provided for in the contract in any shape or form, and yet there is a sense it might be wise to sit down at the table, more efficient for X, Y, Z reasons. Sometimes the client actually doesn't have an appetite to actually, go into a long and expensive dispute. They just want it sorted out. And yet they feel that, offering mediation might be a sign of weakness. What would you advise a client under those circumstances?
Would you mind if I keep that question for the second question that I'm about to address, because I think it goes very much in line of what you're actually asking for.
Okay, well then we'll park that one. But let me do something else, because we were saying that what we would like to do, and Tom, I need to circle back to you on this one, is, if there's a main takeaway about windows of opportunity, what would, your, I don't know, the main takeaway for everyone listening be? Windows of opportunity and mediation, what is there to know, or what would you like people to remember?
I think one of the main things to know about windows of opportunity is there is, in almost every case, one time that you can actually access mediation easily, and which actually makes not only the mediation efficient, but every other process that you dealing with. Let's say arbitration or court proceeding. There are cases where mediation is just not fit to solve any problem. I actually advocated in those cases as well. But leaving purely legal issues aside, almost every case has a window of mediation as long as you look for it. The question is always if you look for it.
That is a very fair point. So we have, I think now
Did you
sort
want
of
to ask me
covered
a
this.
question? Sorry, you said something, you cycled back to me, sorry? Did you
Yeah, I
want
was
to
going
ask?
to say, we've done this, and now it's going to be, before we move a step forward, we're going to move 2 steps back, which is basically going back to you, Tom, and asking you the same question. We've just heard from Amelie that basically every case has a window of opportunity. It's just like the silver lining, you have to look for it sometimes. And that's a lovely takeaway from that first session. Tom, the same question was going to go into your direction, which is, looking back at your intro when you were explaining the twinning process and synergies, is there one main takeaway that you would like our listeners to keep in mind regarding just the basic notion and concept of a twinning process? A life hack, we've called it at times, and that's my question to you right now.
I love a good life hack. Let me have a look whether I have a life hack. No, let me take one step back before I get the second step back as well. I completely agree with Amelie. There is at least one, that's the only addition I would make, at least one window of opportunity in essentially every case. It's a question, for me, it's a question of if the clients are willing to initially already engage in the conversation of designing a process that combines or that contemplates the combination of both processes, and then in a contractual arrangement or in another form, setting up windows already at various points in the life cycle of the dispute, where it is considered, or whether it is, and I think, Natascha, you were asking that what if clients do not want to engage in a discussion on dispute resolution clauses, etc. And that happens more than often. I completely agree with you. Often they have the $2 in their eyes. They just, oh my God, there's so much profit for me. I don't want to talk about disputes. Everything will be fine. And yet, even in those circumstances, I think the astute lawyer will always look out for the opportunity to see whether it is actually appropriate to engage in mediation in order to achieve a settled outcome. The second step back would be, I think that the still prevalent conception that we have litigation, arbitration, mediation, and if you walk through one of those doors, sorry, and if I use now the multi-door courthouse analogy here, you are sort of stuck in that process and you run with it, is so 1970s and 1980s. I think we have moved well beyond that. For a lawyer, all 3 processes are fundamental tools that need to be used at any given time in order to achieve the best outcome for the client in whatever combination. They're not alternatives, they're complementary to each other. And we don't need to focus on the, how should I say, the process itself, and then we just run with it, but we need to focus on the outcome and then design the process accordingly. That's the way.
Natascha, could I also add to this, if I might?
You are up next, and I was just wondering whether Vladyslava wanted to transition to you, but as you've come on, Mary, please go ahead, and let's just, because your topic is actually process design, and perhaps just use this to segue direct into that.
Thank you. What I'd like to do is to comment on that question and then start out on the process design, if I might. I think there is a great deal of argument about when the window is, or when a matter is ripe for going out to mediation in this context. And I step back, and I've always said this actually from the beginning, way back in 1990, is that lawyers are concerned about control and confidentiality in relation to processes. But if you even step back further from that, it's important to know what the decision-making processes are for the parties and for the lawyers to move on. We all have very different decision-making paradigms. Some people need a lot of information, others do it by way of intuition or gut reactions. But what we find, I think, is that particularly in a dispute resolution process, which is couched in the terms of court arbitration or where lawyers are involved, there is a pivotal point where people get to an understanding that there is sufficient information for them to make decisions, or that everyone in their team is able to make decisions, and those with authority to finalise the matter. And I think that is where a lot of these issues about when the window is appropriate, but it also affects process design. And I'll move into that if I might. But before that, I want to say, look, it's an enormous pleasure to me to join you all today. But there is a custom for us in Australia to acknowledge our First Nations people and their elders, past, present, and emerging. So I would like to pay tribute to our First Nations people, if I might. The other thing I'd like to do is to thank the organisers from the Ukrainian Academy of Mediation and VIAC. I'm absolutely in awe of your capabilities to host such an enormous conference with such expertise, and to do it with alacrity. So thank you. I've provided a paper from the committee that I chair at the Law Council of Australia on MedArb. It's a commentary, and it's a guide for legal and ADR practitioners. Now, we prepared that because we've been in a long cycle in the development of alternative dispute resolution in Australia. In fact, we were the first country to have arbitration way back in the very early 1900s, and also took up mediation very early on. But what we found is that we're moving into this hybrid process. We don't use the word twinning, but we use hybrid processes. And we were very concerned in our committee at the Law Council about all of the issues that we're discussing today, and giving some guidance to ADR professionals and lawyers about how to, and also to say, this is a very useful process of a hybrid, whichever way you do it, ARB, MedArb, or whatever it might be. But you do need to really build up your skill base in the ADR processes to be able to implement this efficiently, so that you don't fall foul of it. I had our Chief Justice of New South Wales speak to this issue, and to speak to the issue about lawyers and their obligations from moving from the bar table in a court, for example, or an arbitration, and moving to a negotiation forum as officers of the court, and what that actually means, and your obligations. So we're going to talk about some of those ethical issues later on in this session. But one of the interesting things for me was that the Harvard Law School asked the following question about this: the choice, arbitration versus mediation. When you are not sure which of two common dispute resolution processes, mediation or arbitration, to use to resolve your conflict, what do you do? Mediation is appealing because it allows you to reach a collaborative settlement, but you're worried it could end in an impasse. You know that arbitration would wrap up your dispute resolution conclusively, but it wouldn't give you much say in the outcome. But what if you could get the best of both worlds by using MedArb to help with dispute resolution? And that brings you to the design features. So the first thing I would say is you need to look at where the referral comes from. Does it come from a dispute resolution clause, a private referral, a court order, or pursuant to some legislation in your jurisdiction? And what do you need from the neutral? You need neutrality, impartiality. How do you define the roles of changing hats? And what does that actually mean and how does it work? So we need to unpack that. And we look at the advantages of combining or sequentially dealing with MedArb. So I'm actually going to choose the MedArb process because it's a bit easier to run through some of these design processes about it. But finalizing the dispute, so what's the goal? Do you need flexibility during the course of the development of the dispute? How do you manage the transition? Cost and time savings and efficiency. The reduction of the overall duration of the process. How do you actually manage that? Is there importance in having a collaborative outcome, a consensual process? Is there more durability in implementation and also with the outcome? Are you really looking to enforce whatever is reached at the conclusion of these processes, either by way of the New York Convention or the Singapore Convention? And that's already been mentioned. And what about confidentiality? How much disclosure or, I suppose, bringing out everything that's been stated in a private session if you move from mediation to arbitration? And in some jurisdictions, that is it is important. And what are the perceptions of justice and control? And one of the things that the neutral needs to really look at is that public interest issue about the perception of justice and what that actually means in the process that they're implementing. And then if you're looking at the design of the processes, you need to look at the risks and challenges, because the majority of concerns with the MedArb process arise from the idea that the same neutral switches hats to perform the role of mediator and arbitrator throughout the process. And then you're also looking at, of course, what that means as far as the parties are concerned, and if the dispute is sufficiently large and complex, whether you're engaging experts, as Amelie had raised beforehand, and whether they fit in. Because in mediation, certainly that I have done, is that sometimes you have to mediate in a conclave of experts to get the report that then comes out to go to either arbitration or further mediation. And then you have the procedural concerns of MedArb. There's been quite a lot of, I think, criticism of this process, as well as it looks as if you can get finality. But these concerns are primarily in relation to the dual roles. So do you split it? Do you say, well, we have somebody mediated and a different person arbitrated? I think when you're looking at the design process, it's really important to say we're going to use the same person so that you actually begin to refine the issues. I had to develop a process which was a MedArb, but call it concilio adjudication for our Land and Environment Court. And when I dealt with this, which I think was in 2015, there were only about 7 matters going through this legislative requirement about a section, what was called a Section 34 conference. So we sat down and looked at it and drafted a new section of the legislation to allow for flexibility. And then we looked at what we were doing about a concilio adjudication or MedArb process in planning disputes. One of the interesting things is that when we talk about information, in this particular type of dispute, the information is gathered in a process run by the local council. So there's quite a lot of information already exchanged and called upon pursuant to legislation so that it grounds the process. If we're talking about front-end loading for a normal MedArb, then you really need to look at cost effectiveness and whether you need discovery or how much information you actually need. So you need the parties to sit down and look at that. But I'll go back to the Land and Environment Court scenario, because what we did with that was to say, all right, well, we've got sufficient information when this matter is referred by the registry for a MEDAR before a commissioner? Are we going to have private sessions? And the Chief Justice was concerned about that. Well, less concerned about it than I was, in fact, because there is an issue about not only the issue about disclosure of information or bias and procedural fairness, but there's also the idea of perception about whether the process is going to be neutral and transparent for the parties and one that people can have confidence in. And so what ended up in this process was that no private sessions were going to be held so that you would have uniformity. But there was this fail-safe, and that was if you went through the equivalent of a mediation process with a commissioner, then you had the choice, if you moved into the arbitration portion of it, was to stay with the same commissioner or to send it back to the registry for re-referral to someone else. So that just remained with the parties for choice. And then they moved into the arbitration process and a conclusion of it, which was then made into a court order. Now, I give you this example because, and we have many of them where we design the different sorts of processes, but I think that highlights the issue about private sessions and the disgorgement of information. So in my jurisdiction, in the common law jurisdiction, it's really important that there be procedural fairness, and that if an issue is taken into account by a decision maker, then each of the parties has had an opportunity to hear what the issue is and to make their own argument or respond. In some jurisdictions, it's not as important. But I was looking at some of the, and you'll see this in the paper that I provided to you, but in some jurisdictions, such as in Japan, Japan's arbitration law does not govern the confidentiality of information given to the neutral or disclosed during mediation. But the provisions are governed by the Commercial Arbitration Association's commercial arbitration rules, which forbid the neutral from caucusing without written consent from the parties and imposes on the neutral a duty to disclose at each instance that an ex parte communication has occurred. So in other jurisdictions, that information, such as in Hong Kong and others, is disgorged. So if they hear something, the neutral hears something in a private session, they must actually put it out there when they move into the arbitration mode. The other aspect of moving on is what is put onto the record. That is, I suppose, talked about or provided during the mediation process. So it's not only just the information that is exchanged during a conversation or the negotiation, but also the documents provided during the course of that mediation process, if you are doing it as a MEDARB, and I'm just talking about that process for the moment. So I think there's quite a lot of, there are a lot of issues about how even-handed the process is, and the management of the design and management by the neutral is really important in that regard. And then there are the obligations that flow, not only for the neutral, but also for those who are representing clients. So the neutral has to switch hats, but also the representative has to change mode and mindset about what they're actually doing. Whether they're engaging in a consensual process where negotiation is at the fore, or where they're using strategic advantage and advocacy in an arbitration and dealing with, certainly in my jurisdiction, cross-examination in arbitrations, and in other jurisdictions, perhaps not so much, but more documentation. So I think these matters really come to the forefront when you're looking at these processes, and you need to look at the mitigation measures for this when you're designing them. And so I think that some of these aspects, such as confidentiality, consenting to the neutral, revealing all relevant confidential information if they need to, if they have private sessions, and how that might be managed and how you mitigate problems arising is essential. I think also if you decide that you are going to move to enforcement procedures, whether it is within your own jurisdiction. In my jurisdiction, every civil matter will go to mediation. And I know that might sound confronting for people in other jurisdictions, but it is the way it is. And not only do you go once, sometimes in particular areas, you might have to go 2 or 3 times before you're allowed to go anywhere near a hearing or a trial. So arbitration is very common in our building and construction area, but not as common anymore in other areas because of cost and also because we have an efficient litigation process. So when we're talking about mitigation features, we need to sort of begin to work out where you opt in and where you opt out in these, and whether there are overriding legislation or court requirements that are going to impede moving along and what the outcomes are. But I think I've probably said enough about highlighting the complexity, but I think in essence, what you're doing is looking at information flow, timing, when you might have parallel processes or not, whether you stay at proceedings while you go to perhaps mediation, whether the mediator is utilising a facilitative mode of mediation or they're going to be more interventionist, and when you come back for a decision making and on what basis. And I think the big test is information flow, but also implementation and durability and enforcement. So if I were looking at a dispute design for a hybrid or a system that might be adopted, for example, by insurers or by some commercial entities or government entities, they're the sorts of things I would look at the beginning. And I'll hand it back, I think, at that point, unless there are particular questions.
Okay, I think Natascha has some technical issues and she got kicked out from the meeting. But maybe I would have one question. You mentioned before, and you've talked a lot about the third-party neutral. So I was wondering, what do you think, like, is this matter supposed to be regulated in some way? Like, are the arbitral institutions supposed to maybe regulate this matter or assist the parties somehow in dealing with these difficulties?
I think it's, I'm a great believer in flexibility for the parties. Because I think if you are not adapting to the parties' needs by providing alternatives to litigation, then it becomes much more a structured process that gives less opportunity for finalisation, whether by a consensual agreement or by way of a final determination. And I do a lot of work with parties about designing the process with them as well, because I think that creates more durability. I think there's sufficient in legislative requirements, certainly in my jurisdiction. They give enough structure around it if required, but a lot of these matters actually come through private referral.
Yeah, working for an arbitral institution, it's very interesting to see which kind of different approaches are out there.
Yeah.
Would you like to formulate your life hack or your core recommendation based on your very helpful insights in that sphere?
Sorry, I didn't hear that.
Would you like to formulate your life hack, like your core recommendation based on your very insightful presentation, either related to confidentiality matters or to the third-party neutral or whatever you feel is like most important?
Like the main issue. I think it's really around, if you're going to move from consensual process to determinative processes, you have to watch the confidentiality aspects of it. And I think if you are starting out, you need to be safe and the parties need to be safe. And the neutral's responsibility is to create that safe environment and to create a process that is useful for the parties and there's no exposure. And I think along the way, you need to be very minded of that. So I think that'd be my main takeaway at the moment.
Okay, thank you. Maybe we should move on to the next topic. And I'm thinking and see that Natascha is trying to rejoin. She'll catch up in a few moments. So as we've already heard today many times, although hybrid approaches are gaining traction, there are many additional aspects that should be considered for the proceedings to actually go smoothly. So Amelie will further explore how arbitral institutions are fostering hybrid procedures. They have a personal interest into finding out which kind of tips and tricks you have also for VIAC. Yeah, and the other aspect would be the role of soft law instruments in this process. Amelie, what can we do? What can be done to ensure seamless hybrid proceedings?
Thank you. Let me say that I think that the seamless hybrid proceeding is based on 3 pillars. And far and foremost is training and workshops on how to integrate what the other process is and how to integrate them, because at least from all of us apparently know what arbitration, mediation, and court proceedings are, but there are a lot of students, starting with students at the university, professionals, counsels, in-house counsels who actually never heard of mediation or arbitration. Most people know courts. So that's a starter, but arbitration and mediation is not known everywhere. I was recently traveling to another part of Austria where they actually continuously develop the understanding of what arbitration actually is. So this being said, I think the starting point is transferring knowledge, litigators knowing, contract drafters, M&A specialists knowing the different types of process that they may choose from. The second, what you mentioned, is institutions, and institutions can do a lot when it comes to training. They can train their arbitrators and mediators, create an awareness and understanding. At the same time, and VIAC, for example, the Vienna International Arbitration Center, does this, from my point of view, in a very nice and neat way, because they inserted in the arbitration clause, in the model arbitration clause, they have like an addition that you can choose as a party when drafting your contractual clause, which is that the parties, after initiating arbitration, so we talk about an op-med-op model, after initiating arbitration, they will think about mediation and the appropriate timing. The way VIAC did this was to add it to the arbitration clause. There are other institutions who actually have only an arbitration clause and then refer to something similar in a different section on their website, and then this concerns mediation only. But the way VIAC did it was, from my perspective, in as much smart as someone who thinks about arbitration goes through the model clause and then thinks, oh, there is something I don't know yet. Mediation looks interesting. Well, let's put this into our contract as well. Another possibility is to, and I've seen that in other rules like the one of the ICC, they actually refer to the arbitrator. In the arbitration rules, they say, the arbitrator, you can actually facilitate at any point in time negotiation and settlement ambitions of the parties. And the way doing this is by encouraging parties to consider specific case management techniques. And in those protocol on case management techniques, they actually mention mediation. The VIAC choose a slightly different approach. They actually have also included in their rules the encouragement of arbitrators to facilitate settlements if the parties are ready, which of course includes mediation and referring it to mediation without explicitly mentioning it. When it comes to another possibility for institution to enhance the use of mediation is, of course, costs associated with mediation, and that is one which, for example, VIAC recently reduced in its new rules. in order to make it more appealing for parties to move to mediation. And with that, I would like to comment a little bit on what Thomas said in the beginning about doubling costs and the question of Natascha, if it actually gets more expensive. I don't think it necessarily has to be that way, but I nevertheless think mediation has its value and it costs something. And I think it definitely adds up. It doesn't mean that it needs to, like when the arbitration costs get lower, it might be around the same amount that you would have paid for full-fledged arbitration, but still mediation is an addition. But the value mediation has and the possibilities you have with the mediation are much more than what you would get with arbitration only. That's what I wanted to add. As you asked, Vladyslava, about soft laws, of course, soft laws, as you all know, are instruments. They're like rules, procedure, guidelines that have no formal legal effect like laws written from our government, but they do sometimes guide arbitrators, mediators, counsels in their interaction, in their way of acting in general. And as such, they do have influence in whether mediation is used, how it is, and at what time it is integrated. And for example, also what Mary talked about is if you as an arbitrator would actually act as mediator at the same time, or if you would just refuse and say mediation and arbitration are just too different, and it would actually impair or harm my arbitration proceedings. So please go, I have a list of mediators, but please choose a separate person for that. And when it comes to soft law, and I think links will be shared of the ones I'm just going to mention, which is the Chartered Institute of Arbitrators, who actually published professional guidelines on the use of mediation in arbitration. The same goes for CEDA, the Center for Effective Dispute Resolution, who have guidelines and reports and rules regarding the facilitation of settlement and mediation in arbitral proceeding, as well as the UNCITRAL model law on international commercial mediation, which goes into the direction or hinges into the direction of using both mediation and arbitration at some point in time. Thank you.
Yes, thank you, Amelie. So I'm back. My apologies. I don't know. Me and technology is not a friend today, it would seem. Talking about what you've just mentioned, I think one small point. I mean, you've mentioned institutions, but again, the question is what you do if you're not within an institution. Have you had any experience with just referring to institutional rules without the institution actually administering, something we know from arbitration?
I mean, I think it's a way of using them as guidance. I don't think you really, I mean, personally spoken, I think you would use them in any event. If I have something new coming up in my mediations, I actually look to the VIAC or any other institutional rules and think, how did they solve that? And to what extent can I actually take, what tips do they have for me, even if we're not within the institution? And I think I owe you, do I still owe you an answer to my question, to your question? When it comes to professionals, I do, right? Yes.
Yes.
So your question was, what do you tell a client if it's not within a contract? So It very much goes back to what I initiated this little talk about with, is I think one of the main features is to get lawyers, in-house counsels trained in mediation and arbitration, and get them trained in combining and switching between those processes. Because as soon as this becomes normal, nobody will ask you that question anymore. That's one thing. Unless, but we're not there yet. I understand.
Yeah.
So my normal question is, if someone asks me, doesn't this look weak if I propose to enter a negotiation? I ask them, first of all, why? Why should it? And the second of all, if you are actually really willing to mediate and to enter into settlement negotiations, what harm does it do if you are the first one and the other one actually, for some unknown reason, sees you as the weak party? Just because of entering it doesn't mean that you will actually, you don't give anything away. So what's the fear? What is the fear that you have when it comes actually to a settlement? You may be still successful even if the other party sees you as well. And if you have an experienced and advanced mediator, the mediator will actually balance any kind of imbalance between the parties of either way, if one sees it as a weakness or not.
Would it be then, and I know we need to move on to the next topic, but would it be a fair takeaway to say that as everything in life, it's a matter of perception and also how you frame it at the end of the day? I mean, of course, taking concerns seriously, but you might well say, I am so confident of my case, you know, I'm absolutely comfortable at sitting at the table because, I mean, if we do it elsewhere, I feel comfortable. I know, you know, it's going to cost more money, but I will still win. You know, taking that kind of approach from a client perspective, would that be fair to say it's really just how you frame it and how you think about it in very many situations?
Totally agree, yes.
Thank you, Amelie. I am conscious of time, and I'm just going to ask the organizers also to sort of perhaps tell us in the chat what our time frame is in view of all, you know, the various issues we've been facing with technology. But while we're waiting for that answer, I think we have a couple of questions. Vlada, might I hand over to you to cover those questions, which I think are directed to Mary's topic?
Yes, sure. So the first question that we've got is, how do you handle clients who come for mediation? After you are in the mediation process for a few hours, you believe arbitration would be a better idea or vehicle. How do you transition to that? So how do you propose to the clients that transition?
Thank you for that question. I think it's really interesting because I think we as lawyers and as humans want to walk away from the really difficult portion. So if we're talking a few hours into mediation or where that tipping point is, often the parties become far more difficult because they're trying to hang on to their last space before they can move on. Like, you know, they don't want to give it up. And that's when their behavior can be much more difficult. And you know, we as lawyers, as I said, or humans would prefer we go to something a bit easier and not so confrontational. And I think the skills that mediators develop to deal with enhancing dialogue and conversation, particularly at that point when the parties are intransigent or are venting, is a really important space that we all need to, everybody, upskill and continue to upskill on it because it's not within our comfort zone. If you then say, well, we've exhausted everything, we've gotten to a point where the parties have actually decided there is no way forward in this, and it's important to now make a decision. Then at that point, how do you transition? If the parties have already set it up in the original agreement. It's really important. And I think that comes back to your question earlier on, which is what can an institution do, is to provide the contractual terms for this. So if you already have the parties who have agreed and consented that you remain and be the arbitrator, then you have your pathway forward. And in that contract for the process, it should also outline what you're doing with the private sessions as well, so that everybody's consented about each of those aspects so that the smooth transition can move to arbitration. But then you have to say, what am I doing with the information? In that agreement, it should also say something to the effect that at the point that arbitration occurs, and you would have had a break for a time between mediation and arbitration, then what information is going to be read on the record? And hopefully the parties have already agreed to background documents or whatever, and then they would be read on the record, and then you would have to determine what other evidence is going to be heard during the course of the arbitration. So I think there's that transition point that you have to be careful not to go easily into the arbitration because you feel uncomfortable or they feel uncomfortable, but then it's always important to have a break, make everybody understand that it's being moved to arbitration, and have the mechanisms already in the original contract for the process.
Thank you, Mary. I think it's been very helpful to the participants. And we've received another very fitting question because we were supposed to transition to the ethics aspect with you, Mary, and we've touched this topic a lot already. And I think it's the most interesting and the most challenging part about this topic in general, that everything intersects. So we have a question. Do international arbitration tribunals need a standardized code of ethics for arbitrators to ensure consistency and neutrality?
Okay, can I talk about we're revising the trilogy of guidelines that we have at the moment for mediators at the Law Council ADR Committee. And it was something that I think Amelie was also raising about soft law. I think we're moving to a space now where if there are complaints against the neutrals, then if the determining tribunal or a court or a judge is going to say, well, what is the standard here that I have to compare the behavior of the neutral to? What do I look at? And although they are soft law at the moment, we know, at least in my jurisdiction, that a judge is going to say, all right, well, let me look at the guidelines that the institution has utilised or the Bar Association or Law Society has adopted. And we also have accreditation processes that are currently under review. So although we're talking about guidelines that might be very high level, some of them are quite prescriptive, and I'd have to say that it would not be my preference. And if you're moving towards arbitral institutions, you've got to say, I think, what is the use of this? Do we need to say anything more than what is in the legislation? Do we need to say that there should be appropriate behaviour by arbitrators? I'm not sure I would go that far at the moment, but if you are going to engage in guidelines, I think you need to look at where it's going to end. And I know across the board, there are international ones that are established by different institutions, including IMI. There are local ones. There are ones that are actually in regulations now in some of our jurisdictions. And so that is going to be more, I suppose, influential as far as complaints processes, disciplinary processes, as well as best practice. So it's got two edges to it. And I think everyone needs to sort of sit back and say, what do we want from these? Because they will be influential in due course.
Thank you, Mary. That's been a very concise question to answer to a very complex question to my mind. I mean, this is one of the trickiest things that we actually have to deal with when we do these hybrid processes. Again, I'm conscious of the time, and I'm not quite sure how much we have. I do, however, see we have further questions. Vlada, can I pass back to you for the next questions, and you allocate them as you deem fit?
Thank you, Natascha. The next question is interestingly touching upon the next remarks that Tom was supposed to be making about the various jurisdictions approaches and the enforcement measures. So maybe we can do this question and then transfer to the next topic. How can we effectively integrate mediation into our court systems without compromising access to justice?
To whom is that question?
To you.
To me. Oh, thank you. I don't actually believe that there is an inconsistency or there is an issue with access to justice if you integrate mediation more broadly in the dispute resolution ecosystem. Well, I know we're going back a little bit, but the first time I met Mary, she was on the National Advisory National Alternative Dispute Resolution Advisory Council. Now I got it the right way around, the right way around. And in short, NADRAC. And NADRAC at the time had actually a mandate from the Australian Attorney General to look at ways of how to improve the civil justice system by increasing the use and improving the use of mediation across the board. And one of the results of this mandate was an examination of the system and where mediation might fit in. And ultimately, we ended up actually, well, mandating it in a sense. It was thought of a kind of pre-action protocol step before you even go to litigation. I never see this actually as a problem of access to justice, because ultimately you do not deprive people of justice if it is a formal form of justice in the sense as it is delivered by the courts. Then ultimately, if you fail in the mediation or the mediation fails, I think it's better better way of putting it, you still have your path ahead of you into the more formal justice system. But if you do not need it, if you're actually successful in the mediation and resolve your problem, and I think that's one of the big advantages. The question doesn't actually arise because the access to justice remains on foot, but you may not need that access to justice because you're capable of resolving the dispute beforehand by yourself. And I think from that point of view, I think it's enhancing, actually, if anything, a justice system, and it's no detraction whatsoever from access to justice.
Thank you, Tom. That's a very interesting approach and also makes a lot of sense. Would you like to transfer further to the enforcement issues and the Singapore Convention?
Yeah, we can actually do that. And again, I'm seeming to be the champion of going steps back as well. But one of the things that I was asked to talk about is private international law. But of course, private international law is one of the three pillars of, enforcement is one of the three pillars of private international law. So let me just say 2 or 3 things about private international law, because it relates back to some of the comments that Mary was making about process design, because private international law, I think properly understood, is a risk mitigation tool, a very important one. Because it brings to the parties foreseeability of outcome and certainty of outcome in relation to their choices. And this is what we're talking about here. It's about party autonomy, parties being able to make certain choices in the design, in the setup of their relationship with another party, whether it's a contractual relationship that needs execution or whether it is actually a relationship that is brought on about by a dispute. But it's about choices. And when we look at mediation, when we look at arbitration, we need to look at various points of the process where we make those choices. Now, one choice that we will be able to make is already the contractual stage, when we decide to include a dispute resolution clause of a certain kind, potentially setting up us up for a combination of both processes at the later stage. Now, we know from the arbitration community that there has been extensive litigation about various questions pertaining to the arbitration clause, the dispute resolution clause, in the sense that we know that it is separate, or it's considered separate from the contract. So even if the contract fails, the arbitration clause may survive. Now, the result of that is that we essentially have to think about the dispute resolution clause, the arbitration clause in that instance, as a separate contractual relationship between the parties. And we actually have to think about the issue of private international law within that confined context, as well as in the broader contractual scenario. Now, when we do that, we need to also then consider that when we choose mediation, we need to think about this very carefully for the very simple reason, unlike an arbitration, it does not have a seat. So there is obviously the seat of arbitration, which is very important to various aspects of choice of law and choice also of forum with respect to an arbitration, but we don't have the same thing with respect to mediation. So already at the contractual stage, when we add something about mediation into a dispute resolution clause, we may have to think about at that stage already, do we actually want to prescribe a law that governs that particular aspect of the contract separately? And there are strategic choices about that that even reverberate or even go through right to the enforcement stage later on. But there's two other agreements in certainly in the mediation and arbitration world. As soon as we enter into mediation and we have a mediation agreement with the parties, we need to think about how to set up that mediation agreement and how to design and frame our choices relating to the applicable law and the also the court that would actually ultimately, or arbitration perhaps even, but what dispute resolution process and the jurisdiction in which we want to have that dispute resolution process take place, we need to think about that. And that has consequences because, as Mary was saying, for mediators, there are different regimes worldwide in relation to their obligations vis-a-vis the clients. As Mary very correctly pointed out, there are jurisdictions where you cannot retain information as a mediator, or if you have mediated going forward in an arbitration, you can't do that. And you need to know that. Yeah, so you need to know that, and you might have to make strategic choices as a mediator in the mediation agreement if you encounter this kind of scenario in order to protect you. You could probably even take this one step further, Mary. I'm quite confident that we will at some stage, and this will probably happen very soon, also because I'm working on it and I'm writing something on it at the moment, but we will talk about this very soon, something that in arbitration is very common and very well known, and that is the impact corruption has on arbitral proceedings. And arbitrators are very attuned to that. There has been a lot of research done, red flags, etc. When you talk to mediators, no clue whatsoever. But there are very different regimes applicable to arbitrators who are very often protected from that because it's so well known in the arbitration area. But mediators do not have the same protection. So you might actually run the risk of becoming almost I think in some jurisdictions this might be the case, and an associate to corruption proceedings, because you actually facilitated the corruption by running a mediation to its very end, and you do not have that protection that we have in the arbitration world. So there are very, very important questions at that stage to answer by your choices in terms of choice of law and choice of court, choice of jurisdiction. The same applies to settlement agreements. The parties need to be aware of the fact that they need to make sure that their settlement agreement makes the right choices in relation to the applicable law to the mediated settlement agreement, as well as also if something goes wrong with the mediated settlement agreement, in which jurisdiction this actually should be litigated whether it be for breach of contract or whatever it would be, ultimately tortious claims, but it needs to be considered by the parties, at least in a cross-border environment. This is absolutely fundamental. And when I have mediations of this kind, I always remind the lawyers, and it is sometimes really perplexing how little lawyers actually take this into consideration in the first place, and how surprised they are when they all of a sudden say, oh my God, yeah, I didn't even think about that. This happens actually still, unfortunately, quite regularly. In relation to the enforcement, we of course have in the arbitration world, the enforcement, and Amelie was referring to that, the New York Convention, and the question of whether we can go from a mediation into an arbitration in order to get the enforcement settled. Now, there is actually also an interesting situation which needs to be addressed beforehand, potentially, or considered at least to be beforehand, because there are jurisdictions where you cannot do that, because that jurisdiction has not accepted the fact that there exists a dispute at the time when you have actually settled the dispute. And so when you then try to get the award transcribed or transferred into, sorry, the mediated settlement agreement transferred into an award, you might end up with an unenforceable award because there was no dispute to begin with. So that also has to be considered. You need to look at the potential enforcement jurisdiction, whether it is actually permitted there, or whether you run the risk that a court would actually essentially nullify this or prevent enforcement because the award is unenforceable because there was no dispute to start with. And finally, the last point I make is also relating somewhat to private international law issues, but definitely also to the enforcement issue. It is absolutely fundamental nowadays for mediators to understand the implications of the Singapore Convention and make sure and remind the parties that their mediated settlement agreement ultimately needs to comply with the requirements of the Singapore Convention, the various requirements that it is international and commercial in nature, that it is resulting from mediation. This is actually a really interesting one because that depends very much on how you define mediation, and certain things, like, for example, if you have this mix between arbitration and mediation, then there might actually ultimately be the question, are you already outside the definition of mediation? Is this a different process, or is that still mediation? Written form, signature, etc., and whether there are other grounds of refusal. And now I'm sort of going back to what Mary was just saying with respect to the ethical ones. There's a kicker in the Singapore Convention, and that is that the mediated settlement agreement can be unenforceable because of a grave failure to meet certain professional standards or have conflicts of interests, a non-disclosed conflict of interest on behalf of the mediator. So the mediator actually can be in person a problem for the enforcement later on. So you need to also conduct yourself in a certain way in the mediation also, if it is part of the arbitration, as well as you need to disclose ongoingly, of course, during the mediation, all interests of conflict that you may have, because if they are, or if they have a material impact ultimately on the outcome on the mediated settlement agreement, it might actually end up being unenforceable under the Singapore Convention 2019. And with that, these are my comments on that.
Thank you, Tom. I think it's a very distinctive characteristic of this topic, the circling back element, because we've already spoken about the soft law, but we have one last question from the audience. I will address it to you because you were speaking about the various jurisdictions approaches. So the question is, to what extent can soft law instruments conflict with one another in the context of international mediation? And are there any implications of such conflicts on procedural consistency and enforceability?
I think.
Please, sorry, I'm sorry for interrupting you. We are a bit short on time, so if you could just give a brief.
Sorry, I just had to take a deep breath because I need really to think about that. No, I think the first answer, the answer to the first question is yes, technically that can happen. Secondly, I don't think it makes a huge difference, unless I misunderstood the question. It makes a huge difference because the mediation process itself can be so flexible that you can actually overcome these inconsistencies by adequate design of the process. But that's a requirement for the mediator. You need to understand the conflicts between the rules, and then I don't think it's a problem. And you can, in any event, I think, set it up in a way that it remains enforceable. Yes.
Thank you, Tom. We have gone a bit over time, and I'd like to thank everyone who's still online for bearing with us. But that is not because our speakers were not absolutely compliant with their timing. That is because we started a bit later than we intended to. It is now a time to wrap up, and there are still a few questions out there. And I will take the liberty of wrapping everything up with one which I think is really important. And all of them are relevant, but we don't have time for all, and my apologies for that. And the question is, and this goes to all four of you very, very quickly, short answers. Is international mediation also effective in resolving geopolitical conflicts, or do power politics and national interest make that nearly impossible? And perhaps I'd like to, just pass this round because it is such an important question in our times. Whoever would like to go first, Mary, Tom, Amelie.
I've written quite a lot on this, and I'm going to be writing another article. It's about the 21st century disputes and the fact that they're no longer lineal and have locus standi in courts. And I think mediation processes and consensual processes are the key to unraveling what I call polycentric, multi-party and multi-issue disputes, because everybody wants a say. Whether you're in a first world country or on social media, you want to be able to engage with this. And so currently I'm looking at modelling some of this with some professors at Oxford, and it's a very important issue in respect of human rights, environmental disputes, large community engagement and political disputes. And I think that we need to begin to upskill. It's all very well to talk about, mediation of two-party disputes in a commercial matter, and we all do them. But at the end of the day, the more complex and difficult matters have a very different complexity and also a different dynamic, and they don't get on the train at litigation or arbitration where it is clear that it will have certain parameters and case management processes. They are very disruptive, and at each point, in each pivotal point, they will be different. So you need to be able to manage those. So I'll leave it at that as that example. But can I just say, MedArb is not a one size fits all, and justice, it needs to be seen to be done as well as being done. Singapore Convention will be very important. I do them, and people are not thinking about how they manage those processes, not only in respect of enforcement and where it might be, because there are 58 states that have signed and 18 that have ratified, but also if there is any issue relating to the actual mediation, what law is going to apply, particularly when you do border disputes. So I'll leave it at that. I know we're running out of time.
Amelie.
When it comes to conflicts involving political powers and national interests, I think history shows that these disputes are actually mediated, can be part or can be subject of a mediation. In particular, and one of the examples that exist is investor-state mediations, where actually governments are involved. And as far as I know, the IC as the ICSID has actually already mediated around, I think, 18 or 20 cases in the past year. So there is actually some substance and some need for those kind of mediations as well.
Tom.
I might draw it a little bit broader, but I try to be as brief as possible. I think that the geopolitical environment that we currently have yearns for mediation as a tool to resolve disputes. And I'm thinking here in particular about disputes that involve state parties, and not investor state parties in the commercial sense, but actually different types of conflicts, whether humanitarian conflicts, geopolitical conflicts, etc. And I do very strongly believe that mediation is actually here the key, however done by properly trained mediators who have, on the one hand, an appropriate training in diplomacy, but on the other hand, also an appropriate training in very fundamental, very key mediator skills. I think this is the key to unlocking a lot of potential in a global sense, and could actually really revolutionize the way that we look at also courts like the International Court of Justice, etc. I think there is a lot that we need to better understand in that area. It's done, but it's done not enough. And yeah, I'm looking very much forward to actually doing some more work in that area. And all I can say is we will have that privilege of someone who actually does this kind of work coming to Vienna very soon, and talking about his experiences in this space, actually mediating disputes between state and non-state actors, states and non-state actors. And I'm very much looking forward to listening to that.
I can only second that, so am I. It is now at the point where it is for me to thank you all. So very specifically, Mary, and it must be a terrible time for you. Thank you for accommodating our needs. Thank you so much for all you've contributed. Amelie, the same goes to you. It's been very valuable, and I've really enjoyed also your perceptions and life hacks. And Tom, everything you do for the community, including sharing your insight here, is greatly appreciated. I don't want to end this session, however, without also thanking and shouting out to, there's so many names I think we all know out there in the audience. Thank you for bearing with us. Thank you for your attention. Thank you for being interested in this. And, you know, please feel free to connect. I see some of you are sharing your contacts already in the chat box. Please use it because communication is key, and we can only communicate if we are connected. And one person who has not been properly introduced, and that's because of my delay in signing on, is Vlada. And at this point, my sincere thanks to Vladyslava Donchyk for joining us and for moderating and doing such an excellent job here. We are very grateful that Vlada is with us in Vienna most of the time. She had joined VIAC in 2022. She has engaged in not only an ambassadorship for the VIAC rules in the SCC and CSC countries, CE countries, but she's also continuing her education. Originally, she had a degree in international relations from the Taras Shevchenko National University of Kyiv, but she's now also doing a degree in international law. And I think international law and relations, all of those tie together again to those last words, which is mediation is a tool. It's one of many, and it may work on different levels. And I'd like to pick up what Amelie said. There's always a window of opportunity. You only need to look for it. And sometimes, I'm afraid, also wait for it. But this window has been fantastic. Thank you so much to Louisa and Svetlana for inviting us all. And I think with that, I may, and this Vladyslava, maybe, Vlada, would you like to close the session? I think that would be most appropriate. I pass the word to you one more time.
Thank you, Natasha. Thank you. Thank you to everyone for joining, for bearing with tech issues. Дуже дякую, що ви приєдналися до нас сьогодні. Я бажаю всім мирного завершення тижня і enjoy the rest of the sessions tomorrow and on the weekend.